Hi, welcome to the Libertarian Alternative. My name is Mark Selzer. The Libertarian Alternative is an educational television show brought to your community by the Libertarian Party. Today's guest, Allison Margolin. Thanks for coming out.
Thank you.
And you are an attorney.
Yes, I practice criminal defense in Los Angeles. I do state and federal criminal defense.
And where did you go to school?
Harvard Law School and Columbia undergrad.
Wow. So, how long have you been practicing law?
I was sworn in 2.5 years ago.
2.5 years ago?
Yeah.
And you're already involved in a fairly important federal case right now?
Yes, right now I'm appealing a case called United States versus Stephanie Landa. And in that case, my client is, she was convicted actually of cultivation of marijuana or maintaining a place for marijuana. She was growing for a medical club in San Francisco under the color of law. At that time, she had gone to a meeting of the San Francisco Police Department where they said San Francisco was a sanctuary from the federal laws. She proceeded to set up kind of an open and conspicuous shop, just not shop, but basically a warehouse where she was growing plants for a club. And the DEA...
For distribution to sick
clubs,
people
yes,
that have a prescription from a doctor.
That have valid medical recommendations. And she was at the beginning stage of this and doing it openly because she thought this was, the right thing to do. And actually, the DEA came in and usurped the state authority, basically, and prosecutor her came in, arrested her.
So where is that? What's going on with that right now? I mean, how does the judge? This has not worked so far.
No, unfortunately, just a little while ago, there was a very landmark case that came out from the Supreme Court called Raich v. Gonzalez, and before it was called Raich v. Ashcroft. Unfortunately, the Supreme Court has said that the federal government does have jurisdiction to come in and prosecute people, even when they are in compliance with state law. So the state of the case isn't too great. However, in this case, for example, the judge, and this is a federal judge in San Francisco, had already said that he thought this was too many plants even to fall within that. So now we're trying to go to the Ninth Circuit to hope that someone there will be humane enough to allow my client, who is 60 years old, who is a medical patient herself, to live peaceably and not have to go to federal prison.
Does she suffer from an illness herself?
Yes, she was run over by a car several years ago and suffers chronic back pain and shoulder pain, and she's in need of a shoulder replacement surgery. So she lives with chronic pain, and she was growing for other people to try to help other people. Not take narcotics and not get strung out on other drugs. And for that, this country punishes her.
So she is, what would be the sentence for this if she was to be put in jail?
Well, right now she's supposed to go to prison, actually. I'm doing the appeal. She's supposed to go for 41 months. But astonishingly, if she had gone to jury trial, instead of taking a plea, she would have faced life. Wow. And that's due to her priors, which that she has no problem openly telling people. One was when she was in her 20s for bringing heroin over state lines. She was an addict, and she was coming from Thailand. And her other conviction was a state conviction for possession of over an ounce of marijuana. And under the federal guidelines, that puts you into a life category.
Wow. But she wasn't dealing. She wasn't harming other people. She wasn't convicted of selling it to anyone. She was convicted of simply of possessing it.
Well, maintaining a place for the manufacture of marijuana. That's what the federal guide says. So
where does the case go? I mean, from here, what are you doing? What are the details of appealing it? How do you go about doing that? Right now, it's in federal court, district federal court.
Yes, it's in the Northern District Court.
And you're trying to appeal it to a higher court.
Yes.
Are you going to be able to keep her out of jail?
That's the
question.
During
that time?
Well, that's what I'm doing currently. I just filed with the Ninth Circuit. Well, actually, I filed in the Northern District Court what's known as a certificate of appealability, a request to certify this and let it go to the Ninth Circuit. And even if the judge, who is our judge, doesn't agree that it should go to the Ninth Circuit, because of the process, it must go to a small panel at the Ninth Circuit who decides whether or not they'll take it. So I've just asked for bail pending appeal for a stay of execution of her sentence. And what I'm arguing now is that there's one aspect of the jurisdiction argument that's been overlooked. And that is that the whole idea of the federal power being involved in medical marijuana is that medical marijuana is interstate commerce. And the definition of interstate commerce used to be very large. It's been retrenched in recent years, and that's why we
narrowed.
thought, right, that's why we thought that we might have a chance. But there's one aspect of the original case that actually brought in the concept. It was called Wickard v. Filburn, and it was from the Depression era. And that case is considered to be the basis for the enlargement of interstate commerce. And something interesting that people have overlooked a lot that I'm trying to argue now is that in that case, the wheat farmer, who was the subject of that case, was taking subsidies from the federal government. And in that case, the Supreme Court said that because he was taking subsidies, that he had to comply with the certain requirements that the different bureaucratic agencies were developing for wheat. And that because wheat was, his commerce affected other people, that it was considered interstate commerce. Now, that's considered to be the basis for the enlargement of this concept of interstate commerce and the basis for enlarging federal power. But my position is that something very important about that case that's overlooked is that that gentleman, the wheat farmer, was actually taking subsidies from the federal government.
Right.
And that's why the federal government had jurisdiction, not simply because wheat is something that can affect the larger trade. And so I'm saying, likewise, in this situation, I'm saying we look at this.
She wasn't taking any money from the federal government to grow marijuana, medical marijuana. And that's obvious. But for some reason, it often seems to me that many of the justices on the Supreme Court seem to have a different version of the Constitution and the Bill of Rights than I have seen. It's almost as if they have a little special version that's given to them after they swear it. Here's the real version of the Constitution and the Bill of Rights that we use to make our decisions. And this is not given to the public. That's what it often seems like to me, because how is medical marijuana interstate commerce? That makes no sense.
No, it really doesn't. I mean, basically, my view is that justices, they have their own political opinions, and you can really find any kind of law to justify what you want to do, or any legal position to justify what you want to do. And what's astonishing to me is that there are very few federal judges out there, nobody on the Supreme Court or in the higher courts, other than the Ninth Circuit, who really stand up for the human right, to do what you want so long as that doesn't harm other people, the libertarian principle. And I think medical marijuana is, a prime example of how we have, a freedom that we really should be granted, or a freedom that we have that, let's just say, is not respected by our government.
Not respected by the government, because the Constitution says that our rights are inalienable and are not granted to us by the government, but we are born with them, and the government should be there to defend them.
And not deprive us of them.
Yes. So what are you going to do? What's your plan of action this time? If you manage to get this appeal and keep your client out of jail, what are you going to do? Are you going to have a different strategy going into the next stage?
Basically, the strategy I have now has been somewhat different than what I had before. One of our claims is also ineffective assistance of counsel. And while that's still part of my claim, into the Ninth Circuit.
So that wouldn't be you?
No, that wouldn't be me. I didn't represent her originally. There was a conflict of interest amongst the attorneys. So I have a couple grounds. You always want to give these justices many grounds, especially non-controversial grounds, on which to side for your client. And when you're just representing an individual, as opposed to just looking at the cause, you want anything to be, if anything is useful to help her stay out of prison, I want that to be the grounds upon which they grant my appeal. So
now, for those of the people out there watching that don't know, medical marijuana was made legal in California by Proposition, what was it? 215, Proposition 215, and that was how many years ago?
That was 1996, and then in the last couple years there was SB 420, which was a Senate resolution which was supposed to basically enforce the medical marijuana law. Now, the state was supposed to set up a registration system, people were supposed to get ID cards, none of this has taken place. So, whether or not that law has made a big difference is kind of questionable. But one more area in the law I wanted to discuss with you about my grounds for appealing, which is really relevant to all of this, is that there's been some change in sentencing laws. And now the idea of mandatory sentencing under the federal guidelines in federal court has been declared unconstitutional. And so that's another ground